today. So yeah, in the last class we were discussing about this topic of this idea of legal order being as a dynamic order. So on the other hand, moral order could be both static as well as dynamic. I hope I was able to make sense of what Kelsen is talking about. You can probably, if you look at the extract there, okay, from his own reading, then you can understand. I gave you guys the example of non-violence, okay, lack of animal cruelty in Jain philosophy, okay. So here, a similar example has also been given by Kelsen, okay, where he says, from the norm to love one's neighbor, one can derive the norm not to harm one's fellow man, not to damage him physically or morally, to help him in need, and particularly not to kill him. So you see from that one more, grand norm, okay, of this. I think this is a moral norm, okay. You can derive all other moral norms, okay. They have to be consistent with the grand norm, okay. So when it says that love one's neighbor, it can in no way be said to mean that, okay, you are justified in harming them. You cannot do that, okay. So that's another example that he provides, okay. And then further he says that perhaps one might reduce the norm of truthfulness and love for one's fellow man to a still higher norm, such as to be in harmony with the universe. On this norm, a whole moral order may be founded, since all norms of an order of this type are already contained in the content of the presupposed norm. They can be deduced from it by way of logical operation, namely a conclusion from the general to particular. This norm, presupposed as the basic norm, supplies both reason for validity and the content of the norms deduced from it in a logical operation. So here's the difference that he is talking about. Whereas in case of legal norm, you only get the validity from the higher norm, whereas in case of a moral norm, you do not just get the validity, you may, okay, not in all cases, you may also get the substantive content of the lower norm from a higher norm. So that's the idea, okay. So legal norm is a, legal order is dynamic, whereas moral order could be both static as well as dynamic, okay. But when he says that legal order is dynamic, it does not mean that, well, everything is allowed, okay. It's not like that. Some constraints might be imposed. So for example, a constitution itself might impose certain constraints on what can be legislated. When there is distribution of power between the center and the states, for example, Article 246, 7th schedule, it also imposes certain restrictions on the matters in which parliament can make laws and the states can make laws, and the areas in which both can make laws, and what happens if there is a conflict of laws made by both the center and the state. So yeah, so that's what's being talked about. So some kind of constraints are definitely imposed on the lawmaking authority of a particular body authorized to make laws. But then, apart from those restrictions, the content of what can be made or cannot be made is not predetermined by the grand norm in case of legal order. That's essentially what the idea is, as has been propounded by Kelsen. However, yesterday one student, I remember, I forgot her name. She had raised a valid question. Uh, so so when I gave you this example that, well, 377, okay, the way it was interpreted, okay, earlier and the way it is interpreted now, they seem to be quite, different, okay, quite opposite, and quite differently understood by different judges, okay. So what happens in those cases, okay? So that example is the one that I gave you to tell you that, yes, this is exactly what the Kelsen is talking about, that yes, the specific content is not necessarily determined by the grand norm. The grand norm, for example, in our case, let's assume is that, well, the constitution ought to be obeyed, okay. So that statement, okay, that norm in itself does not determine whether homosexuality is allowed or homosexuality is not allowed. So yes, that's the idea which was being pointed out by Kelsen. Okay. uh, okay, so let's proceed to the next portion where he talks about validity and the importance of basic norm. Okay, so when he talks about validity of a norm, okay, he's saying that the norm is a norm that is valid is in existence, okay, and a norm that is not valid, okay, does not exist, as simple as that. Okay, so he's saying that existence and validity of the norms are the same thing. Okay, if they exist, okay, a norm is a valid norm is a norm that exists, and a norm that exists is valid. Okay, now when he says exists, okay, this is something that applies to the physical world, to the factual world. I know that the laptop in front of me exists because it's in the factual world and I can perceive it using my senses, okay? But when it comes to norms, I cannot do that, okay? So how do I know that, how do I know that a norm which is not subject to being perceived, okay, which is incorporeal, actually exists? Okay, so there is no way for you to physically perceive a norm. Okay, as he says, okay, it's the mental activity. Okay, and through that you have to know that, well, this norm exists. Okay, now a norm exists, okay, only when it is validated by another higher norm. Okay, so when we talk about existence of a norm, we say that it is a valid norm. So you will ask the next question, so what is a valid norm? A valid norm is a norm which is validated by yet another higher norm. Okay, so we took many examples, okay, of this sort. Okay, so for example, the tax collector is demanding that you pay, tax. Okay, the norm would be you ought to pay the tax because the top tax collector has demanded that you pay tax. Okay, now why is that norm, valid? Why is it not merely subjective, and why is it objectively valid? Okay, that's because the tax collector, for example, has demanded that you pay tax under a certain provision of a statute. Okay, well, then what will be the norm there? Whatever the statute says, okay, whatever the provision of the statute says, you ought to follow. Okay, well, why would that that norm be valid? Okay, so let's assume that that act has been enacted by the parliament, okay, in accordance with all the procedural requirements, and that it is within the competency of the parliament to enact the said legislation. Okay, so that's a fact again. So what would be the norm? So the laws which are enacted by the parliament following appropriate procedures, and if it has the competency, then that law ought to be obeyed. Okay, now you might ask, okay, why should I follow, why should I care about the statutes, okay, laws passed by the parliament? Well, then one may point out that, well, the parliament is authorized to make those laws under so and so provisions of the constitution, which authorizes the parliament to make laws, and the parliament has competency under certain provisions of the constitution. Okay, well, then what will be the norm there? The norm would be that, well, the constitution says so. Okay, so then you would ask, why should I care? Okay, the norm would be that whatever the constitution says, the constitution ought to be followed. Okay, now you may again ask, why should I care about what the constitution says? Okay, so why, the question with respect to the norm would be, why ought I to be bound by what the constitution says? Okay, so that's the last question I think you will ask. Okay, so what answer, if you were to ask someone, okay, this question, can that person provide you to satisfy that you ought to follow what the constitution says? Okay, there will be no answer to provide further justification for why you ought to follow what the constitution, obey what the constitution says. Okay, now the validity of that grand norm has to be presupposed. Okay, validity of that norm has to be presupposed. Okay, now what is this idea of presupposition is something that one may ask. Well, let me give you another example that may make it little more understandable for you. Well, so imagine a child, okay, who goes to school. Imagine a child who goes to school and is bullied by other children there. Okay, the child is quite unhappy. Okay, child is not quite happy with what has happened to him. Okay, uh, and ends up in a brawl with his fellow mates. Okay, so he comes back home. Okay. Uh, and tells mother, well, this is what happened to me. Okay, I've been bullied and I didn't like it. Okay, so I ended up being in a brawl with them. Okay, the mother says, well, you ought not to fight with people. Okay, the child says, why should I not fight with them? The mother says, well, you ought not to indulge in violence. Okay, the child says, why ought I not to indulge in violence? Okay, then the child then the mother says, well, this is what our religious principles say, that we ought not to indulge in violence. Okay, then the child asks, why ought I follow what the religious principles that we believe in say? Well, the mother says, well, the God has said that we ought to follow what God has decided what those religious principles are, so we ought to follow what God says. Okay, now at this stage the child could say two things. Okay, yes, I am bound. Okay, I ought to do what God says. Okay, or the child could say, why should I care, okay, what God says? Okay, if the child says the second thing, okay, the entire premise that the mother has developed, okay, of why the son should not indulge in violence, okay, the whole premise, the entire this logical argument that she has developed, falls apart. Okay, so at this stage, the child has to accept. Okay, the child has to accept that, well, God has said this. Okay, I ought to follow what God says. Okay, so that's the ultimate grand norm there. Okay, in that moral world, I'm not talking about the legal world. Okay, in that moral universe, that's the ultimate norm. Okay, if the child were to question that grand norm, this entire argument that the mother has developed, this entire pyramid of argument, falls apart. Okay, so that's the idea of presupposition. Okay, that's the idea of presupposition. You have to take it as given, and if you do not take it as given, then the entire structure of this entire structure of norms which exists falls apart. Okay, so that's the idea of logical presupposition. For us to, so similarly, when it comes to legal system, if we are to make sense of this legal order, okay, we have to also presuppose the existence and the validity of, there is no question of validity. Okay, we have to we can use the word validity. Okay, we have to presuppose the validity of the grand norm. Okay, so that's the idea of grand norm. So I tried to explain this whole thing to you earlier. Okay, a similar logic is also applied in the physical world, that if you trace back all the causation, ultimately it goes back to the first cause. Okay, and then you can ask, okay, what caused the first cause? We do not really have the answer. So many people, especially the religious apologists, okay, religious people would say that, well, there has to be a first cause causer, and that cause cannot be caused by another causer. So it has to be something which is omnipotent, omniscient, okay, whatever it is. Okay, so that has to be God. Okay, so that's what they say in the physical world. Okay, so just like that, this is what our philosopher Kelsen is saying. This is how exactly it works in the normative world. In the legal normative world, the God would be the for you it will be the grand norm, and whatever the grand norm says, okay, it ought to be followed. So that's the idea, okay. Now similarly the same goes for our constitution as well, okay, same goes for our legal system as well. So you may start with any lower order norm, you can then ultimately trace it to the competency of the parliament to make such laws. And then where does the parliament derive its competency? You can refer to, for example, the seventh schedule, okay, and the three lists, okay. And then you can also look at whether it violates the constitutional principles. So for example, part 3, okay, whether it is in accordance with that. And then ultimately, if all those criteria and competencies are fulfilled, then you say that yes, you can trace it to the constitution, okay. But the constitution in itself is not the grand norm, though. This is something that should be clear to you, because constitution is a document, okay, it's a legal document that's in the factual world. So where is the norm then? The grand norm would be that whatever the constitution says ought to be followed, okay. Now the question that arises, okay, well, I will address that in a while, okay. But if you look at the example which has been given in the book, okay, in the book you see that it's talking about Australian Constitution which commenced in 1901, but it did not start then. So they ultimately trace it to the British Constitutional Acts, which ends in Glorious Revolution of 1688. So that's how he traces it all the way from the Glorious Revolution. But as you know, in India's case, we need not trace ours all the way to Glorious Revolution. The reason being that we do not trace the validity of our constitution, for that matter, from the Government of India Act 1935 and going all the way to we do not do that, okay. There has been some political facts, okay, that had unfolded, okay, in the Indian historical context, okay. What were those? So nor do you trace, okay, the existence of Indian Constitution from Indian Independence Act. You do not do that, okay. It is from the fact that, well, Indian people fought off the British, okay. That's a kind of revolution, and by virtue of that historical fact, we have adopted a constitution for ourselves, and then from that fact, okay, we can derive the consequent, okay, the parallel norm, then that, okay, we ought to follow whatever the constitution says, okay. So that's where it ends, as I understand, in the case of India. But in the case of Australia, okay, the author has taken it all the way to Glorious Revolution of 1688. Now the thing is that, so you see that we cannot talk about the grand norm in the absence of certain physical developments, okay, certain happenings in the physical world. So for example, in the case of Australian Constitution, they have traced it all the way back to Glorious Revolution of 1688, and in our case, let's trace it to the freedom struggle, okay, the freedom movements that we had, and ultimately we gave to ourselves, okay. It's not a constitution which has been given by others. We gave it to ourselves. The constitution says, we the people of India. So we have given it unto ourselves, this constitution, okay. So from that pure hard fact, okay, you can come to the normative conclusion, okay. But then at the same time, you have to keep in mind that, well, it is not that fact of struggle for independence that give from that fact itself, you do not directly come to conclusion about the norm, for the simple reason that the realm of is different from the realm of ought, okay. So you have to keep these two separate, okay. That's what is talked, even the author has talked about, okay. So it's said that following Kant and Kelsen, we acknowledge that the basic norm and ought or solent cannot be derived from the historical event of the revolution settlement in the case of Australia, for example. Yet it is highly improbable that the basic norm would exist if the historical event had not happened, okay. So how do we account for this jump from one particular fact to a particular norm? So it says that the Kelsenian explanation would be along the following lines. The actors that brought about the political settlement after the Glorious Revolution willed that the norms expressed by the Crown in the Parliament ought to be obeyed as supreme law. in a similar fashion we can say that, okay, those who adopted the constitution, okay, the constituent assembly as it adopted the constitution, okay, they also willed in a similar way that henceforth this constitution would be the, okay, grand norm, okay. So in a similar way, the parallel facts are there, okay. In the absence of that facts, this grand norm would not be possible, but you do not derive the grand norm directly from the facts, as they are in two different worlds. So it's a kind of interpretation of the same, okay. It's from the will of those who have adopted the constitution that, okay, we will be bound by this constitution, and hence you have a constitution, okay, not the constitution itself, okay, that we ought to follow what the constitution says, as the grand norm in our case, as I understand, okay. However, the discussion is not that simple, okay. One might say that the constitution itself is the grand norm, okay. But the problem is that what is the constitution, okay? What is the constitution? Okay, one may say that the constitution means what the judiciary interprets it to be. So should we say that whatever the judiciary says, in fact, is the grand norm? Well, that's a problematic statement that I leave up to you for you to decide, and you will discuss this in your constitutional law topics, okay? Whereas there is another view that, okay, not after the basic structure doctrine that had been laid down by the court, okay, but before that, even the parliament exercised tremendous powers in amending the constitution to whatever extent they wanted to, but now it is constrained by the basic structure doctrine as was developed by the Supreme Court. So prior to that, one could have said that, well, whatever the parliament says ought to be followed, and that's the grand norm. But that's not the case any longer. We know that there is a basic structure constraint on what the parliament can do. So should we say that? But then, we do not know exactly what the basic structure is. Basic structure is, at the end of the day, is determined by the court itself. The Supreme Court has done that quite in many different cases, starting with Keshavananda Bharati. Okay, so what should we say? That the grand norm is whatever the judiciary says. Okay, so it's very problematic. But for the sake of our understanding, let's say that, well, whatever the constitution says ought to be followed, and that's the grand norm in India's case. Okay, so I hope I made some sense here in trying to explain this idea of validity and basic norm. Did I make sense?
Yes, sir.
Okay, any difficulties in understanding anything here? Okay, I would assume that you guys are clear. Because I have to complete, I'll proceed. So the next topic is with respect to customary laws. Okay, what is the status of customary law? Okay, customary law systems in the works of Hans Kelsen. So you know that for thinkers like John Austin, customary laws are not laws properly so called. Okay, they become laws only to the extent that they are recognized in the judgments of the court. Okay, so once the courts recognize them in their judgments, okay, they, not because they are customs, okay, but because they have been recognized in the judgments of the court, they become law. Okay, properly so called. Okay, and as opposed to that, H.L. Hart had a different position. Okay, H.L. Hart says that in primitive legal systems, okay, the one that you understand as customary, no, we wouldn't even say that these are legal systems, okay, because Hart would say that these primitive societies had a set of laws, but not a legal system, okay, not a legal system. So it does not make sense for him to say that, well, primitive societies had legal system, because for a legal system to exist, you need to have primary rules of obligation, and then you need to have secondary rules of power, okay. But the secondary rules of power does not exist in primitive societies, so they have set of laws, okay, but there's nothing really to unify them, okay. So as opposed to both these thinkers, Kelsen had a different position, although much similar to Hart, okay, but the difference lies in this, that Kelsen said that even these primitive societies had a legal system, okay, not of the same sophistication that you see in modern legal systems, but they had a legal system nonetheless. So you can call it as customary legal systems, okay. So he did not say that primitive societies merely had a set of laws, but they also had uh, customary, okay, legal systems, okay. Now why does he say so? Well, that's because the customary laws, okay, fit into the definition of legal system, the legal order that he has just defined, the pyramidal system, okay. That even in customary legal system you can trace the validity of a subordinate norm and from another higher norm and from another higher norm, and then you can trace it all the way back to one grand norm. And if that is the criteria of validity, and if the grand norm here is the glue that holds the entire structure together, then why ought we to deny this primitive societies this tag of having a legal system? So that's something that he contributed, okay. So he said that even primitive societies had legal system, and those were customary legal system, okay, not of the same kind that we have today. So there's an example which has been discussed, okay, explained, okay. So he says, in a social community, okay, a tribe, it is customary that a man who marries a girl pays a certain amount to her father or uncle. So that's the customary practice, okay. If a man marries a girl, he has to pay a certain amount to her father or uncle. If the groom asks why ought he to do this, the answer is because in this community such a payment has always been made, okay. That is because there is a custom to make this payment, and because it is assumed to be self-evident, then that the individual members of the tribe ought to behave as all other members customarily do. This is the basic norm of the normative order that constitutes the community. So he's saying that in a primitive societies as well, you can derive, if you can trace the validity of a subjective command, okay, subjective command ultimately to a grand norm, then why should we say that primitive societies did not have a legal system? So this is a very important contribution that Kelsen makes, okay. There's a reason behind this, okay. The reason is that if you remember, John Austin said that international law is not a law properly so called, okay. As we understand, it's not positive law, it's this positive international morality as he calls it, okay. So he denied it the quality of being called law properly so called. The reason is that if you remember, for Austin, the presence of law required the presence of a political community and ultimately a sovereign superior, okay. Now when it comes to the nation states, no nation state considers it to be subordinate to others. Everyone is considered to be autonomous, politically autonomous and equal, irrespective of their size, population, etc., etc. Although in practice there are differences, let's not go into all that, but it is assumed that they're all equals, okay. Now how could there be a sovereign among equals? Now there is no international sovereign, okay. It does not exist. So if there is no international sovereign, then there cannot be any law properly so called, as Austin would say. There is only positive international morality. Well, unlike that, in Kelsen's work, as you see, you do not need a sovereign, okay. All you need is that for you to trace the validity of a subordinate norm all the way to a grand norm, okay. So if you look at all the human rights, okay, so human rights are protected within the domestic jurisdictions, okay, and then quite often you see courts interpreting human rights in the context of some international treaties and conventions, okay. One would say that, well, we trace the validity of this subordinate norm all the way to those treaties. Then you can trace it all the way to the UN Charter maybe, okay. So this is one way of saying that, well, international law is a law properly so called. Okay, you do not need a sovereign. All that you need is a grand norm. Okay, and if you are able to trace the validity of a subordinate norm all the way to those grand norms, then well, you have a legal system. And if you have a legal system, then you have laws properly so called. So international law would be laws properly so called. Now we will stop this discussion on international law here, because it will take you to much more complicated discussions on monism and dualism, which is there right here in this reading. So I suggest that you guys go and read that as well. But because of paucity of time, I'm not going to be able to deal with that. But it's very much part of this reading. Towards the end, you will find it. So yes, that's the idea. Okay. So one more issue that we need to deal with is the question of relationship between validity of basic norm and effectiveness of basic norm. So if you remember, Kelsen says, well, individual norms, not the basic norm, okay, even if they are not effective, in the sense that if someone is able to break the law without being sanctioned, okay, without being punished, okay, that infraction in itself, okay, that successful infraction in itself does not make the law not law, okay, it is still law, okay, that's what he says, okay. Why is that? Well, whether the law is law or not does not depend on whether it is effective in this case or that case, not that, okay. So whether it is law or not depends on whether it is a valid law or not. If it is a valid law, you should be able to trace it to a higher valid norm, okay, and all the way to grand norm. That's the idea. But what about the grand norm in itself, okay? What if the grand norm in itself is not effective? So he's saying that you cannot arbitrarily choose a norm to be the basic norm or a grand norm, okay? Basic norm, yes, you have to presuppose it, no denying that, okay? But for you to presuppose the basic norm has to be effective as well, okay? That it is generally effective in a particular community. So for example, a particular group within this country says that, well, from today onwards, whatever we say would be the law. It cannot be a grand norm because most of the people do not follow that, okay, so it cannot be the grand norm. Now in this country, let's say that, well, whatever the constitution says, okay, ought to be followed is the grand norm. That's because the constitution is generally effective, okay. So you see that there is a connection between effectiveness of the grand norm with that of its validity. So that's essentially the idea. So to what extent can we really say that we can keep the basic norms separate from the reality from the factual world, okay? So effectiveness, as you know, okay, how effective a law is in the factual world, okay. Whereas we ought to follow a particular norm, okay, a particular command, okay, or for example, we ought to follow what the constitution says is a norm that lies in the normative world, okay. We say that the factual world and the normative world are in different worlds, okay. The norm is an interpretation of what is there in the facts, okay. So that's what it says, okay. But then we see that if that were totally the case, then the norm would exist no matter what happens in the factual world. But it seems that changes in the factual world does in fact make changes in the normative world as well. So how does this entire idea then fit into what the entire philosophy that Kelsen has developed? So it's said that the basic norm, like all other norms, is an interpretation of a set of facts. Without facts, there are no norms. This is not contradiction of ease or distinction. The basic norm is not derived from facts, but is an interpretation of them. Okay, so this is what is said as a way of getting around this problem that we come across, that we see that yes, norm should be norm despite what happens in the factual world. But it seems here that, well, some changes in the factual world, okay, does in fact bring changes in the normative world, okay. So how can we say that the normative world and the factual world have, no relation? Well, they're saying that, well, they're not causally connected, okay? They're not causally connected. You would say that, well, the changes in factual reality does not create the norm, okay? Is the changes in factual reality brings about a renewed interpretation leading to a new norm. Well, as I said, this seems to me to be a kind of word salad, okay? But then, yeah, if you were to believe what Kelsen says, okay? At least you see that within the theory that he has developed, there is a kind of consistency and it is of great help to us, okay? In many different situations. So, for example, when we say that, well, international law is a law properly so called, okay? Now, when Holland says that international law is the vanishing point of jurisprudence, well, that's not really the case. Then how else do we account for example, international law is a law properly so called? Then such philosophies, okay, such theories of law comes to your rescue. Okay, so you might say that even if one country successfully escapes the application of certain international law, okay, that fact of escaping the grip of the law does not make it any less of a law. It is law nonetheless. Okay, but if generally this legal order, international legal order, is totally not effective, then there is no point saying that, well, there is a law there. So yes, this is what the idea is. So Kelsen said that a constitution is effective if the norms created in conformity with it are by and large applied and obeyed. Okay, if they are widely disregarded, a different norm may emerge as the basic norm. So as you know, this is a very important remark. Okay, why is it an important remark? Because see, no one would say and no one would go there and then say that, well, constitution ought to be followed is not the basic norm. Okay, so how do we know that the basic norm is no longer a basic norm? You will know that when there is general disregard and disobedience of every other norm which is created, not created, which trace their validity all the way to the grand norm. Okay, so if that's the case, if most of the people most of the time do not respect any of those norms which are validated by the grand norm, then you can say that the grand norm has lost its effectiveness and hence the legal system does not exist, the grand norm does not exist, the grand norm is non-effective and it is no longer valid grand norm. So this is what he says. That's why it is important for us to understand here, as Kelsen says, okay, effectiveness is the condition of validity, but it is not validity itself. Okay, effectiveness is the condition of validity. So what does it mean? If there is general disregard, disobedience of all the norms which exist, okay, which trace their validity from the meta norm, the grand norm, okay, then you can say that yes, effectiveness in fact is the condition for validity, but it is not validity itself. So what does he mean by that? It means that in every other cases of ordinary infraction of the laws, well, because the law is little less effective compared to what it should be, that in itself does not make it an invalid law. Okay, so that's the idea. Okay, that's how both H.L. Hart as well as Kelsen try to save legal positivism from the onslaughts that it had received in the works of legal realists. So yes, that's the idea. Okay, now examples with regard to this has been given. Okay, you guys can go into start reading all those examples. Okay, so let's take the example of a jaywalker. Okay, let's assume that there is a law that says that you ought not to go across the road when the light is red, but many people do in fact go across the road. Okay, when the light is red, does it make the law invalid? Well, that in itself does not make the law invalid, because the law can be traced all the way from the grand norm. But if most of the norms of that particular legal system are generally disregarded by the people, okay, it could be for many reasons. Okay, here you might find an indirect connection between law and morality. So if all the laws, okay, made by a particular legal system are of immoral nature, then you would say that, well, such a legal system would lose the respect of the people, and because of that, ultimately most of the, because of that, most of the norms are legal norms are not followed, and ultimately lead to the ineffectiveness of the basic norm, and hence the basic norm is invalid. So that's why he says that effectiveness is the condition of validity, but not validity itself. So yes, that's the idea of relationship between effectiveness and validity, as you see in the works of Hans Kelsen. One last thing that I would like to address, okay, is the logical unity of legal order. Okay, so the question is whether a particular norm belongs to a particular, legal order or not. How do we know that? Well, you should be able to trace all those different norms ultimately to the same, grand norm. Okay, so grand norm is the glue that holds all the norms together. Okay, so yeah, so for example, a law made in Assam regulating pattern of law, land holding, compared to a law, for example, made in some other states, okay, with respect dealing with some other aspects of, individuals' lives, okay, do they come under the same legal order? Well, they do. Why? Because you trace them all the way back to the same constitution, okay? Not the constitution, the grand norm that says that we ought to follow what the constitution says, okay? So that's what holds this, these different legal norms together, okay? And that's the glue, okay? So whether different legal norms, okay, belong to the same order or not, the answer to that would be whether you will be able to trace it to the grand norm or not. If you are able to trace the legal norm, okay, validity of a particular legal norm from the same grand norm, then you can say that they belong in the same legal order. Now, one important, that's the legal unity, logical unity of a legal order that he's talking about. Okay. Another important assertion that he makes is that this is very normal, okay? A lower norm cannot contradict or violate a higher norm from which it derives its validity, okay? That's not possible. So, for example, look at the how judicial precedents work, okay? Laws might the inferior courts, your district courts cannot decide a matter as opposed to a precedent laid down by the high court. The same goes for high court as opposed to the supreme court. They cannot do that, okay? So you see that a lower order norm cannot be in conflict with the higher order norm. So that's quite what Kelsen is saying. The same goes for legislations as well, okay? The bylaws made by municipal board cannot be as opposed to any laws made by the state legislature or center, okay, central legislature, and the laws made by the central legislature cannot go against that of the constitutional restrictions. So there is always this idea that a lower norm cannot contradict or violate a higher norm. If it does, then you do not have a legal order there, okay? Now, what about the conflict of norms at the same level, okay? So he says that it's just not possible. Two norms at the same level cannot possibly be in conflict. Why is that? He's saying that it's logically impossible, because law cannot expect you to do something and at the same time not do something. This is something, the principle of absurdity that we find in statutory interpretation that we are going to discuss later on. That law cannot ask you to do absurd thing. So if there are contradictory directions to you within the same law, okay, the judiciary has to intervene and interpret in accordance with certain other principles, okay? So essentially the idea is that if there are conflicting norms, okay, then they are essentially ineffective, okay, they are meaningless, okay, as Kelsen would say. So are they a possibility? Well, they might exist if people ignore them, if people do not look at them, okay? But if you have to ask, well, does it make sense logically? Okay, it does not make sense logically. Okay, so if a conflict arises between norms at the same level, okay, the court has to come to a solution about what to do about two conflicting norms at the same level. So there are certain other principles which are used in while interpreting. One is that lex posteriori derogate lex priori. What does that mean? The law that has been enacted subsequently will will supersede a law which has been made earlier. Okay, the idea is that yes, the sovereign has changed the mind. Okay, now, so it supersedes. Okay, it over not overrules. It supersedes what has been intended earlier. Okay, another one is that if you have a general legislation and then if you have a specific legislation, we say that the special laws that supersede the general legislation. So for example, your transfer of property acts are there. Okay, that's the general legislation, and there could be specific legislation dealing with how agricultural property is to be transferred and all that, okay, within the states. Okay, so in such situation you have another principle known as lex specialis derogate lex generali. So these are some of the principles, okay, of interpretation which come to the rescue of the judges while interpreting conflicting provisions in a particular statute. Okay, so yes, that's what he says. Okay, so the idea is that conflicting commands at the same level, conflicting norms at the same level just does not make any logical sense. Okay, and Kelsen says, okay, that such command is simply meaningless and therefore no objectively valid legal norm exists, okay, in such situation. But judges, as you know, in such situation find a way using those two different principles should such conflict arise to come to the right conclusion. But as you know, if they are at the same level, okay, then then Kelsen would say that, well, it just does not make any sense and hence such a law does not exist.